Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Severine Saintier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law. Hello, welcome. Thanks for joining us here, podcast number 17. As always, we're indebted to our sponsor of Unpacking Contract Law, Newcastle University Law School, but we'll tell you more about them as we get through the podcast. Today, we've got the rather exciting case of Barton and Morris. And exciting, I would say, not just because of the substance and because there's a lot in the case, but also because I think the 3 judgments will bring out some of our own differences in approach. I have the privilege of introducing the case and then the facts, and then to fan the fire a little bit, and I'll be damned if I can't make some kind of sparks fly. The facts of the case are surprisingly simple. Mr. Barton, an, I would say, unlucky, possibly untalented property developer. Oh, that's not fair, is it? From what I can tell, at least, I would say he's fallen in love with a place called Nash House. Nash House was owned by Foxpace. On 2 occasions, Mr. Barton had attempted to buy the property, but each time he'd had to forfeit his deposit, and therefore he found himself at a loss of £1.2 million. That's a bit more than unlucky, I would say. Anyway, in order to recoup his loss, he first considered buying and then selling the property again, but he eventually decided to call Foxpace and have a chat about it. There's some contention about exactly what was agreed, but it's quite clear that the only sums they discussed was a £1.2 million commission and £6.5 million as the purchase price. Now, working through the judgments, it seems that there's a consensus that both parties only really had the sale in mind at 6.5 million, and that neither had really put their mind to what would happen if the property sold for less. We can talk about that in a bit.
You're already biased towards Leggett in the way you are describing the facts, I would say. But
you want everyone to be biased in direction of Leggett, Severine. I can see. I knew you couldn't hold back. Anyway, there was a consensus then that they were going to sell the property for 6.5 million and Mr. Barton was going to get 1.2 million. Mr. Barton then eventually introduced a seller, Weston, and they agreed to buy the property. However, they found there were some issues in relation to HS2 and therefore eventually reduced the purchase price to 6 million. Is that correct? Yes. I think. At least less than 6.5 million. After the sale, Mr. Barton then decided to claim his 1.2 million he believed he was owed. And at first instance, the trial judge found that there was a unilateral contract that becomes important later on for 6.5 million with a 1.2 million commission. The difficulty with that is, of course, they never reached that price. So what should the commission be? At the Supreme Court then, Lady Rose gave the leading judgment and she found there was no contract, and she discussed in that context implied terms and also in interpretation, and also there had been no unjust enrichment. Leggett, dissenting, found that there was an implied term and that Mr. Barton was due a reasonable price, and Lord Burroughs, also dissenting, also agreed there was an implied term and he should be repaid a reasonable price for his services. It all sounds so simple, but Severine, Maggie, was the case decided correctly?
I can see Severine's about to speak. I'll let you speak. Go on, and then I disagree with you positively.
This is a really interesting decision. As we were chatting before, as I was reading Lady Rose, thinking, yeah, that makes sense. We usually tell our students, what is not in the contract is as telling as what is in the contract. That all seemed reasonable. And then I read Lord Legate's judgment and actually got persuaded that actually, the implicit reasonable standards, etc. So no, I do not think the right decision was arrived at.
Oh, great. We've got a disagreement.
And what a surprise. Can I just point out the absolute surprise that Séverine agreed with Legate? I mean, that's just, knocked me off my chair.
Yeah, he even mentioned good faith. Only, 3 words, 3 lines, but, yes.
But he mentioned it twice. I wondeed whether anyone had picked up on that. He even managed to sneak in the words good faith twice in a judgment that has nothing to do with good faith.
So why do you say the dissenting judgment to be preferred, as they say?
So yes, there is a contract, and so the position, Lord Legate's way of phrasing is beautiful. Yes, I am a little bit biased, but I think, the language in which he phrases things are very clear. And so even though it's at times a tiny bit difficult to get when he was talking about the strong sense of the meaning of if and only if, and I had to write things down and to hold on, what is he saying, and etc. But the default position, summarizing his position and that of Lord Burrows, because on this point they both agree, the default position is that just because it is not said into the contract, there is a default position that Barton is entitled to a reasonable sum, and the fact that the parties did not say anything about what if the price of 6.5 million is not reached, that is not an exclusion of him being entitled to a reasonable price. So I think the position of the majority is that the fact that it's not there negatives or excludes the fact that it cannot be there. So I am persuaded by the default position is that Barton is entitled to a reasonable remuneration. He would have been entitled to a £1.2 million if the property had been sold at 6.5. And therefore, just because it doesn't say anything for what has happened, i.e. what is referred to as Plan B, does not exclude his right.
Well, that's the question, though, isn't it? Really, whether there was a plan
Maggie,
B.
go on. What do you think? Do you think
it might be useful? Yeah. Well, I was just going to say I know exactly what Severine means reading Lord Legate's judgment and indeed speech rather, and that of Lord Burrows. The word that I would have for those speeches is they're very beguiling and very elegant, but actually, ultimately, I would suggest to you not convincing. Can I try and persuade you?
You can try, Maggie.
It's worth, well, okay, I'll try. I'll try quickly. It's worth for students just peeling back to the sort of very essence of the, what they would call the roots to Mr. Barton's claim, just so a student is clear if they look at this case, really what this is about, because there's quite a bit of contract law in there. Firstly, express term, remember, explicitly agreed. And I think all members of the Supreme Court were agreed there was no express term that dealt with what, if any, commission Mr. Barton was due if the sale came in at less than 6.5 million. So we can jettison that as a route to his solution, as it were.
I'd like to come back to that point later on.
Well, I think that was found by all members of the Supreme Court, no express term on that point. It was all on implied term. So now we move to implied term. And this is also quite interesting, I think, because all members of the Supreme Court are again in agreement that there was no implied term as a matter of fact. So if you remember those things about workability and obviousness, I think there is agreement amongst all five that actually Mr. Barton does not succeed on that route either. So effectively, he's left with two routes. One is contractual and one is restitution, unjust enrichment. We can deal with the unjust enrichment. Probably you might want to come back to that. I don't know. But again, all members of the Supreme Court, although I think Lord Burrows would, in the alternative, have found unjust enrichment as a route for Mr. Barton, but certainly four of them jettison unjust enrichment as a route. That is a non-contractual obligation because the seller here has been arguably enriched, that is, saved having to pay the commission. But the majority certainly have rejected that. Now, that in itself is quite interesting because I think it shows that I probably almost say, in fact, I'm going to say, it's an indication of a sort of possessive terrain that is contract law. The Supreme Court is saying basically to restitution, unjust enrichment, this new upstart, get out of it here. Look, this is contract, not your terrain, but out. And that's very clearly coming across, I think. It's only Lord Burrows a little bit lukewarm on that, possibly because of his academic interest in unjust enrichment. And that's a point of difference, interestingly, between the Supreme Court and the Court of Appeal. Because the Court of Appeal, remember, would have said, no, sorry, Mr. Barton, you haven't got a contractual route here to what you're claiming, but we'll give it you on unjust enrichment. And the Supreme Court is saying, no, you got that totally wrong, Court of Appeal. So that in itself is quite interesting. Supreme Court is staking out the perimeter fence of defence for contract law. So yay to contract lawyers, get out of it, unjust enrichment. So effectively, we are left with the only route that Mr. Barton has is this implied term, but as a matter of law. The beguiling elegance, as I put it, of Lord Leggatt, and also Lord Burrows, and they're kind of like riding together, I would say, psychologically and mentally. Perhaps their approach is very similar. They are basically saying, implied by law is wider than implied by fact. And we are heavily influenced here by the Supply of Goods and Services Act, 1982. And Lord Leggatt builds up this idea of actually that's really just codification of the common law anyway, which I think is fair comment. And so he's saying in the absence of anything expressly agreed, then the common law, now probably you'd articulate that in the language of Section 15 of the Supply of Goods and Services Act, Mr. Barton is entitled to a reasonable fee. And that's why Severine, he was going on about this idea of you've got an agreement of whatever it was, 1.2 million if the sale was 6.5 million. But he's making a great deal of play, I would say, on oral evidence that there wasn't any agreement such that it was articulated as if and only if. Meaning, to perhaps a pedantic lawyer, to be fair, the difference between you only get any money at all if it reaches 6.5 and simply saying you get this money if it reaches 6.5. Now, it is beguiling elegant, but, it's a very lawyer-like way of looking at ordinary language. And do ordinary people actually speak in that way, if and only if? And I would suggest to you, no, they don't. They would say, you get 1.2 if we make 6.5 million. That's it. And that's really what Lady Rose, I think, is saying. There was an express term, but only on 1.2 million on a 6.5 million sale. And by its nature, that excludes anything else. And that effectively is what the majority is saying.
Are you not persuaded by Leggatt's little example of the person going to the top of the cliff and then jumping, and that it could actually, some people would interpret that as, she has jumped off the cliff. In fact, no, she hasn't. She's just jumped.
Yes. It reminds me very much, it's Hoffman-esque, is it not, in its play on language. But do you not think that's a million miles, really, from the reality of what we've got here? You get 1.2 million if we make a sale of 6.5.
But in a way, so yes, it is a pedantic lawyer, but isn't that a beautiful pedantic lawyer argument that actually, unless it is expressly stipulated into the contract, the position of a contract is presumed to include an implied term unless it's been expressly excluded. Therefore, using lawyerly skill to say that actually just because precisely because it is not said in the contract, then we can find a door by which to slightly open and say, actually,
come off. Lord Legge, in many instances, just like Lord Hoffman and Lord Steyn before both of them, I think, would say the purpose of contract law largely is to meet the reasonable expectations of businessmen, or ladies, we should say now. So
yes, and so therefore here the standards are that all the thing about, what is implicit, and looking at the commercial standards that are applicable, that are implicit and not necessarily said. As Legat said, gosh, guys, you've got better things to do than just putting it is completely impossible to put everything in the contract. And so there is a point. No. So the pragmatic position is such.
That's not pragmatic position. That is forcing on the parties an agreement which actually they never made.
Smiling.
This reminds me of why we started this podcast. I could sit here listening to you two all day. Let me add a little bit of I promised a spark, so I'm going to add a little bit more. What do we think, just stepping back one more step, and let's discuss the facts a little bit more. What do we think the importance is that this is actually an oral agreement rather than a written one? Because all judges make quite a lot of that. And I feel like I'm reading something into it, but it would be interesting to hear what you think in terms of what each of them was saying when they tried to basically recount the contract.
Well, I suppose this is an aspect of what I'm trying to say about the reasonable expectations of businessmen. It's oral. You might, looking at it through the lens of a pedantic lawyer, think that's very unwise for a transaction of this nature. Why was it done orally? But by the same token, contract law is trying to meet the reasonable expectations of business people. If that's how they've done business, then that is how they've done business. And the law's responsibility is to give life and meaning to that they had agreed. So the lawyers and the judges have a difficult exercise because, for example, Lord Legge has written about this actually in the Guessman case. When he was in first instance, it was something that I think that was quite close to his heart at that point, because he made a great play about the difficulties of witness recollection and sort of imprinting in one's memory. And there is no such thing as an accurate memory, because one's memory gets overlaid by replaying it or listening to other people or reading one's witness statement several times months after the event. All of that is going to genuinely, honestly, become totally distorted through time. So courts and lawyers have a real difficulty when everything is purely oral. So remembering exactly what somebody said and where there's very little contemporaneous documents makes it very difficult indeed. So they do talk about the paucity of the evidence. So that's an indication to them of the struggle, as it were. And further, for the Supreme Court, remember, they are at least 3 stages removed from the oral evidence. So when you get to the Supreme Court, there's no live witnesses relaying what they said. All they have got is the transcripts of what happened in first instance, and then what was reviewed, as it were, because you don't really get into the essence of the evidence on the second time in the Court of Appeal. And they are thirdly removed. So it makes it much, much harder to be absolutely sure that you've got it right in terms of what was said and what was agreed. Now, that's a major point, I suppose, of a practical nature, which Tim you've alluded to in this particular case. You would expect something to have been in writing ordinarily, but that's so be it. It's not on this occasion.
I know, and so for me, yes, that is so. In a way, it is particularly telling. So I think I am not going to reveal anything that will surprise people when I say I'm a relationalist. And so therefore, actually, in a way, that is particularly telling that, we are very far removed from us having a sale failing through and, oh my God, I am out of pocket by 250 quid for them. But here, 1.2 million, it's quite a bit. But it always surprises me, actually, that for such huge amount of money, nothing is reduced into writing. So here I am, my lawyer had things, for God's sake, guys, do put something in writing. But on the other hand, it also reflects the trust, the way indeed business people do business.
But I think it's also worthwhile looking at a little bit at the background facts of this. As Tim alluded to at the beginning, Mr. Barton was out of pocket.
Yes.
He had no moral or legal claim against anyone to recover his 1.2 expenses. He'd lost them through his own commercial judgment for good or ill, okay? And it was the seller here...
That's where the talent comes in.
Okay. It was the seller here. If you look at the sort of background, the feel of this is they had a mutual interest in the sense that, and only in this sense, Mr. Barton would like to recover his 1.2 million. What a surprise, wouldn't we all? And equally, the seller wants to get rid of this property. And a number of sales, for one reason or another, it's obviously been difficult to market. So they had a meeting of interests, if you like, in this tiny little area. And so reading in the background, it seems to me, and I think that probably was an influencing factor for the majority, I would suggest, it was the seller saying, well, look, Barton, we do have a common interest here. It's for your 1.2 and we want to get rid of the shop. If we can get a sale for 6.5, then in our budget, as it were, you could get back your 1.2. And that's why I am saying it is pedantic lawyer speak to say, oh no, what they really meant but didn't say was you get your 1.2 million, but maybe something else if the sale is less than that. It's not actually what they were talking about, if you think about it. And that's really, I think, what Lady Rose is trying to say. And then to use, as Lord Legate does, interestingly, a point that only came up in the Supreme Court, not in first instance or Court of Appeal. That's terribly interesting. Only used the point about the statute and this idea of a reasonable remuneration. That suddenly comes up as an argument on the third time of trying here, Mr. Barton. And Lord Legate seizes on that and says, that's a good answer, because we can say there is an implied term as a matter of law because of the statute, and because it's an implied term by a matter of law, the burden of disproof is on this instance the seller, not Mr. Barton. And because it was an oral and there's no contemporaneous documents, they've got real trouble here. They can't displace that presumption that he's entitled to a reasonable remuneration. That's in part why I say this is sort of elegant, very clever, and therefore beguiling reasoning. But actually, I would suggest that the majority are right. This is very far removed from actually what the deal was.
But
so could we stop with that? So if we say for a moment that it being an oral agreement and people can't really recollect properly and all this kind of stuff, where do we stand then with the position of the court that the English court has traditionally always taken, which is it's not our job to improve on the bargain? And I think that's a solid position that's always been taken.
Their difficulty is working out what the bargain was.
Quite. So are we considering here that we might have a different approach then? Is there room with that in acknowledging that maybe this isn't the full agreement or not a very good recollection of the agreement, that the court in fact has some room to then say, maybe this is really what you agreed. This is what you recollect.
No, because
but maybe there's some room here to improve on the bargain.
Yeah, I know. That's sounding very close to making a bargain. The job is merely to work out what their bargain was.
Well, no, we know that there is a bargain.
Yes, but that...
Right? So we're talking about two different things here, and I think we are now going from implied term to interpretation, which I always had in mind. But we are moving here from saying this is what you recollect, but that may not be accurate. In fact, what is much more likely is that you agreed why.
No, for me it's clear that it is not interpretation. I think it is really clear.
No.
You know, the whole thing is, what does the silence mean? Does it mean that it is absolutely clear that it was 1.2 million is only available in one set of circumstances, and
is this if or if, but only if?
Only if.
Yeah.
Or does that mean that, okay, so the payment is 1.2 if the sale is 6.5, or a reasonable remuneration in
you see
other...
that's the creative bit is what I'm suggesting.
That's where we disagree. That actually the default position is that yes, they didn't say it was not discussed, but can the silence be interpreted as an exclusion? Well, no.
Well, actually, no. If you look at the language of the Supply of Goods and Services Act, a reasonable remuneration applies as an implied term, originally by common law, now by statute, unless the parties have agreed something else. And the majority here are saying the parties did agree something else. There is no room for this, and that is why it is not surprising that nobody went on about it at first instance or Court of Appeal. It has no relevance. It's only that it was seized upon by Lord Leggatt and Lord Burrows as a mechanism for the route, as it were, to what they obviously felt was the correct outcome. So the reasoning, they are using that statute as a main plank of the reasoning. And that's the point of difference, I think, between the majority and the minority, because the majority is saying it has no relevance. It might be very different if we change the facts and have this an ordinary sale with an estate agent. All right? Nothing like recovering expenses and all this sort of gambling in the background, as it were, Mr. Barton and these people in these sort of business arrangements. Section 15 is much more about that sort of bog standard ordinary transaction. So if the seller says nothing to the agent about what commission, then naturally the common law, now we would see it in the language perhaps of Section 15, would say, okay, that doesn't mean the contract fails for lack of an essential term, because the common law can fill that by saying, okay, you said nothing about the remuneration. It's a reasonable remuneration. What is the market going rate for an estate agent's commission on a sale of a house of this nature? That is a million miles factually from the Mr. Barton trying to recover his wasted expenditure in the past on dealing in property.
I like the idea of the too uncertain bit, and I think that was picked up by Lady Rose as well. But on the if and only if point, I mean, a lot is placed on risk allocation, right? Who is taking the risk for this not happening? And Leggatt picks up on this, and I'm not quite sure I agree with him on his position on risk allocation as a function within contract law. I think it's actually quite fundamental. But if we look at the language here, it's not mentioned at all, and the fact that all concluded they hadn't really put their mind to it. Is that then the correct risk allocation? The fact that both parties had not thought about it at all, that the risks should then fall on Mr. Barton?
Yeah, they'd not thought about it.
But he was just doing it
simply because
for fun.
It was not part of the agreement. You know, you don't think of things that are not part of your agreement. That is the basic point I think the majority are trying to make. The agreement was, Mr. Barton, you have a chance of recovering your wasted expenses. You've already lost them, effectively. They are lost unto you, but we're giving you the chance of getting them back. if the sale makes 6.5 million. I haven't thought about what trousers you're wearing or the colour of your sweater or all the other things that might be in the background, because they're not relevant. The sale has to make 6.5 million. That's why it's a sort of pedantic thing about, oh, did they say if but only if? Well, do you know, ordinary business people don't speak like that. It's implicit in what they're saying. If we make 6.5 million, then you could clear your 1.2.
But it still leaves the space of what happens if we don't make 6.5.
No, that's what I'm saying. There is no space, because the whole heart of the bargain is it makes 6.5. True, then there's the good faith point that probably, Severine, you want to pick up. And it's a very nice one, actually. If the seller manipulates the price by a bit sharp practice with the buyer, so it comes in at 6.49, whatever. Do you know what I mean?
Yes,
that would be, and I agree entirely that I think all of the majority,
the majority as well did say.
Everyone would say yes.
Trick.
That would be a very good example of an implied qualification, if you like, on the bargain that they have reached, that in achieving whatever sale price is achieved, there will not be any bad faith in manipulating that figure.
So of course I'm going to jump on the good faith or the dirty trick, but for me that is...
I think that Lord Leggatt makes that point in that setting.
He does make that point, but that was also mentioned. To me, that is interesting, but, it didn't happen. I think perhaps what is more interesting is the fact that straight after the sale, the Fox Space offered a goodwill payment of £430,000. So therefore, in a way, it shows that it must have entered their mind. I know they didn't.
No, it doesn't at all. How much of these...
but we can't take that into account, though, can we? Ex post facto.
How much of these parties spent in legal costs in fighting this first instance Court of Appeal, Supreme Court? This could purely be a commercial judgment that actually, to pay the guy something is a cheaper solution than fighting this through three layers of court. God knows what the legal bill is on this one. Very, very expensive. So that could simply be, it happens every day of the week, a commercial judgment. What can we pay to get ourselves out of this hassle? They are business people. They're probably into property. I don't know what their business is, but they're certainly not into legal proceedings and the wasted expenditure and managerial time in that. So, offering him something to get rid of it must happen every day of the week. And you can't conclude from that. No, you can't conclude from that whether there is any rights or wrongs.
Okay.
I think Tim wants to say a word from our sponsor.
Oh, you took it away. I had it all lined up as well. Do you know who knows everything about...
a neat lead-in. I was giving you a neat lead-in.
I had it all worked out and set up. Do you know who else has got it all worked out and set... No, okay. Our sponsor...
No, that works. Keep going. Keep going. That works.
Newcastle Law School is now offering a brand new LLM in emerging technologies and the law. Find out how law, economics, politics and society intersect in a digital world. Visit ncl.ac.uk to find out more. Thank you, Newcastle Law School.
I suppose that's interesting. Thank you, Newcastle. I suppose that's interesting because this case, like many of the ones that we are arguing about, actually it's contract law. So this is commercial life. So digital is sort of a modern way of seeing that, but it's law is not an island. So I suppose a module or a program that you're running at Newcastle that sees law in its business context, it must be very useful to ordinary people. It's only old stuffy people like me are only interested in black letter law. But most modern people want to see economics and politics and how law sits with business and so
Absolutely.
forth. So,
and the comparative contract law course is amazing.
But Maggie has not received any remuneration from.
No, I haven't. I've not had any of my 1.2 million commission, to which I feel I am honestly due in good faith.
And there's a good faith in there. This is too much for me. I can't.
That was for Severine. Yeah. That was
for all the audience and for Severine. Let's jump into Unjust Enrichment for a minute, because that is one of the.
You haven't said what you think.
Oh, I have a whole thing. I'm going to reveal all.
Oh, I see. How very coy of you.
Right. No, I do. We'll come to that in a bit, because I think we can get rid of Unjust Enrichment fairly quickly, can't we?
Well, that's a bit rude, but I mean, it's an emerging area of great importance, is it not? But
she says after I was going to say it's been emerging for a rather long time.
Well, not when you compare the common law, contract law, for goodness sake. You know, are you trading 800 years or so?
The next few conferences are going to be difficult for us, isn't it? If anyone, any of the lawyers are going to be there. Please don't. Let's not go down that route. And right.
Sorry if there are restitution lawyers listening. We do love you. Unjust enrichment is really important. As a civil lawyer, you know, obligations is part of it.
Well done, Severine. Thank you.
I thought it was quite neat. I can't remember who said this, but you'll probably correct me. I thought it was quite neat. One of the lordships, it might have been Lady Rose, I don't know, talking about unjust enrichment and saying that it was concerned with qualification of consent as opposed to impaired or vitiated consent. And it's the impairment or vitiation is the sort of bog standard contract law way of looking at things. That is mistake, duress, undue influence, for example. So we contract law does have a lot in common, I think, with unjust enrichment. There's a sort of touchstone or a point of meeting, but the Supreme Court here is referring to unjust enrichment as a qualification of consent. In other words, this money or this benefit, this enrichment that the seller has, it's a qualified right to retain that, as it were. I don't know what you wanted to say about unjust enrichment. I'm not an expert. Well, I can't claim to be an expert on anything, of course. But
I don't think any of us are, so let's talk about it. It's what we do best. I think we qualify that even in our introduction, don't we? It's unsolicited opinions is what we deliver. Unqualified and unsolicited. The case
that they noted was Benedetti and Soreris, if I'm saying it right. So restitution, unjust enrichment lawyers out there, perhaps that is a bog standard, a very well-known case, much like we would say Hadley and Baxendale is very well-known to contract lawyers. But Benedetti and Soreris, I don't know. Who knows anything about that?
I
don't. Okay.
I wrote down other cases. Actually.
Well, I just made a note of the 4 steps, which I suppose is very well known to restitution lawyers. That has the defendant been enriched? Is it at the claimant's expense? Was that unjust? And are there any defences? So I think that 4 things comes from the Benedetti case, maybe many others.
I wrote these down as the D'Argamo.
Oh.
So I don't know whether that's the Benedetti.
Right, okay.
You know, I wrote it down as it was summarised by Lady Rose in bracket D'Argamo. So forgive us, restitution lawyers, if, you know, we clearly show
ignorance. We are showing great ignorance, but at least we are acknowledging that ignorance.
A great thing we're doing there. Yes. So if we were to assume for a moment that they didn't have a contract and that Mr. Barton just simply introduced the buyer, do we think there would have been a benefit then? I mean, would we be able to go down the...
no agreement at all about commission, none of that, all of that stripped away, just purely that he was assisting the seller in finding a buyer.
And he'd made quite a lot of losses, you know, along the way.
Okay, his motivation was to recover. Okay, the motivation was to recover those losses, but there was no bargain with the seller. And nevertheless, he had incurred some effort, as it were. And I think Lord Leggatt made that point here as the justification point for the implied term, actually. Mr. Barton had made a considerable effort to assist the seller here.
Is the effort the point or the benefit?
No, in the implied term sense, I think that was a relevant point for the minority.
Yes.
That is not about the unjust enrichment point. You're quite right, Tim. That I think is purely focusing on what benefit or enrichment. And so, well,
you heard that, right, Severine? You heard that?
Yes.
I did.
If you think about it,
your face was beautiful, Tim. Oh my God!
If you think about it, the effort that Mr. Barton went to is likely to be reflected in a benefit to the seller if it comes off, as it were. But they're not necessarily the same values, so you're
exactly.
quite right.
I think
we need to focus, So we need to focus on what benefit the seller has had. I suppose one could argue they have saved themselves the normal commission that would have been paid to a standard estate agent. So I suppose you could quantify it in those terms and see that is an enrichment. And I think the Lordship said the only question in this case would be, if it is a question of unjust enrichment, whether here that enrichment was unjust. So there wouldn't have been an argument as to enrichment because of the benefit which the seller gained from Mr. Barton's activities. So I think if you strip away all the contractual trappings, if you like, from this, strangely enough, I think you're right. Mr. Barton's position would be stronger.
Well, to the extent at least that they'd asked for it. I think that's an important part, is that probably they would have had to somehow indicated that they wanted him to introduce...
Or simply sitting by and not saying anything and allowing him to go on and do all of this work.
Kind of an acquiescence type.
I would be worried about that, not knowing any unjust enrichment law, really. But I think his case would have been stronger. Of course, not for the 1.2 million, but for whatever a reasonable commission would have been for the price that was...
135,000.
Yeah, maybe so. So actually, he's in a worse position because of the bargain that they struck.
Which is an interesting point, isn't it? And so I'm wondering, and this is not something that could have been changed, I think, at the Supreme Court, because, and I did promise I was going to reveal a suggestion. I don't think this is something that could have been remedied at the Supreme Court element, but in the fact that this was an oral agreement, I wonder whether at first instance the finding of facts was not quite as elegant as it could have been. I wonder whether the bargain that was actually struck was Mr. Barton saying, I need to recover 1.2 million. Foxconn then saying, Foxpace, whatever they are, Foxpace saying, okay, that's great. We're looking for 6.5 million. And they're going, okay, cool, let's carry on that basis. Neither foreseeing, of course...
but that's too vague. What the hell does any of that mean?
Well, I would have assumed that it meant that if Mr. Barton introduced someone to them and they accepted that price, calculating in, of course, that 1.2 million is due, then actually the purchase price didn't really matter that much.
Why?
Because to me, commercially, that makes most sense, because...
No, I don't see that.
Mr. Barton has no influence on the final negotiations. But Foxpace has every option to say, right, we've factored in the 1.2 million. We're not going to enter into agreement with them because that's too expensive for us.
What are you saying? Do forgive me, but I don't follow
Well, 2 points. One is that the finding of fact of what the deal was sounds to me not like the most commercially reasonable explanation. The most reasonable explanation was that Mr. Barton wanted his 1.2 million. Mr. Barton...
No, that's viewing it purely from Mr. Barton's perspective.
Well, not really, because if we consider who has the influence over this, right? Foxpace always has the option of saying no. right? It's not like he's the agent and he's going to enter into an agreement. Mr. Barton's their agent and he's going to sell for whatever price. That's not what's happening. What's happening is that Foxpace had every opportunity to say, right, if we get a foreign buyer from Mr. Barton's end, we have to add 1.2 million to whatever the price is going to be.
No, that's cart about the horse, as it were. If the sale is 6.5 million, then we've done our calculation. We've got room to pay you your 1.2 that you're desperate to recoup. That's it. The seller has no moral or legal obligation to Mr. Barton for 1.2 or indeed any sum.
But who can influence the price? It is Foxpace who can make that decision. Foxpace is in the best position to be able to say, you know what, we're not entering into a deal with that person.
No.
And Mr. Barton can't influence the price.
The price is arrived at by the market, and they already had difficulties finding a buyer. And all of this comes to be writ large because the eventual price that they were able to achieve was, of course, less than the 6.5 million that they wanted to recover. So it's all about what the seller's asset is worth in the market and what the maximum sum that they can achieve themselves to on a sale of their asset.
But it's a simple calculation I would make as a seller. Right? If I hire two estate agents, one gets 5% and the other one gets 2%. In each scenario, I factor that in. The actual agent who's introducing me has no influence on the price that ultimately I'm going to decide. And why would Mr. Barton agree to introduce someone?
Because this was his only chance now to recoup his 1.2 losses, a considerable sum. This
but
was a gamble.
But he couldn't say, no, hold on, don't enter into an agreement with
But then he would have lost.
Of course not. He's taking
somebody else.
He's taken the risk. He's already out of pocket to the tune of 1.2 million. This is his last chance to recover that money. It is purely a risk, and he takes the view that it's worth doing some work to assist this sale because this is his chance, his only chance now. If the sale makes 6.5 million, then he recoups his 1.2. So he's got every motivation to assist the sale and to maximise that sale price. And the market price is what determines the eventual sale. I'm sure the seller would have been quite happy if the sale had come in at 6.5 or indeed a higher sum. But they couldn't find a buyer at that price. There was some problem with HS2 planned line going close to the wretched building. And that's what depressed the eventual sale price. So the seller could say, we're also the loser here, actually, because we wanted 6.5 million and our budget and our planning and our business model and our assets, maybe our solvency, who knows, because we don't know the background of that, is all predicated on getting at least 6.5 million. Okay, we are factoring in our commitment to Mr. Barton for 1.2 if it makes 6.5, and that's where I come in. If it makes 6.5.
Where we disagree.
Yes. Well, because ordinary people don't speak like that. You don't say, I will give you pocket money, dear child, if, but only if, you do your homework. You just,
I'm fairly sure that's exactly what my
parents what I tell my kids.
I will give you pocket money if you do your homework.
Have you done planning practice? No. Okay.
There you are. It's how normal people speak, surely. Have we convinced you? I don't think we have, or I haven't convinced anybody by the sound of it.
I don't think that was ever going to be an option. I mean, we didn't start this on the premise that if and only if we all agreed we would end the podcast because we'll be going on for a long time.
Anyway, Tim,
I have tried
absolutely.
Tim, where are you? You're going to come off the fence now.
Whether you are on the dissenting judges.
Four again. Well, okay. So I don't think the facts are quite as clear on and also again, and this is where Maggie and I have disagreed in previous podcasts, the difference between interpretation and construction. I think they could have gone further on construction here, particularly because it was an oral agreement, right? And it was 5 years ago. What the parties said, and I think there's much more in there that the court.
Well, the court has to do its best with the evidence it has.
Absolutely. So that is where we are. That I will accept.
Yeah. Life is not perfect.
So from that point of view, I entirely agree, and I also agree with the position that the court should not be trying to improve the bargain between the parties. I do not find the implied term argument.
Go on. No,
Go on. Carry on.
Yeah.
One last ditch at the legacy.
Are they trying to improve the deal? No, they're just trying to show what the deal really was.
Yeah, it's a difference of interpretation as to what the deal was, I suppose. Given the paucity of the evidence, and as you say, everything was oral 5 years ago, it makes it very difficult.
So that's the other point I would have been willing to go down, is to say, actually, there was no agreement. Right? This was a unilateral offer. The unilateral offer was not accepted. Can't have been, right?
Well, that would be a very easy way to jettison the whole thing then. You're not entitled to anything.
Well, no. Because we all agreed earlier on that if he'd not had an agreement with them, then unjust enrichment would come in. Based on the fact, not for 1.2 million, obviously. But actually then we would say, well, the parties never agreed on anything with this regard. That contract has nothing to do, basically, with this. And actually we have either a new deal, unlikely because nothing was said, or we can go down the unjust enrichment route here and say...
we're not an unjust enrichment restitution lawyers,
so I'm going to be very careful with that one.
I think the background would be very relevant to this on the question of whether it's unjust or not. So even if you remove all the trappings, as I was saying, of contract law, I don't think that's the end of the story, that the context and the discussions and everything else would be relevant.
Yeah. What I found particularly interesting here was... I think Lady Rose mentioned that in part, was the fact that the benefit is fairly difficult to define, and there's nothing really to give back, and the possibility of giving something back is quite difficult here. So that was one of the points that I really thought was quite interesting.
What do you mean the benefit is difficult?
Well, you've benefited by Mr. Barton's services in whatever way he was operating in order to smooth the passage of a sale. You'd simply have to find, courts dealing with that difficulties of quantification day in, day out. They just have to find a figure that fairly represents the benefit that the seller gained from that and hasn't paid for. That would be purely an assessment.
The benefit is clear. Barton introduced the buyer.
Yes.
So
the difficulty, I think Tim's point is the difficulty is putting a figure to that.
Okay.
I think that's just
on
what
the one
courts
hand. The
do
other
all
hand
the
is to
time.
the extent that they actually asked for it, right? Lady Rose, I think, has difficulties with that when she's talking about unjust enrichment, is that basically they didn't ask Mr. Barton to introduce anyone. They only asked him to introduce someone at the level of 6.5 million. Right? So then we define the value.
If you're saying there was no benefit, then therefore that's really an argument. There was no benefit to the seller for any introductions by would-be purchasers at less than 6.5.
So we could compare that. We could compare that with the and that I find interesting. It's the same kind of thing. If someone came along and decided to dump 500 litres of water in my front garden that I never asked for, I can see that someone would value 500 litres of water quite a lot. but there's no value to me.
We're straying into restitution law,
that's
so
the
I can't
point I
really
find
comment. But would that be a benefit to you? It's not a benefit in the abstract. It must surely.
And
be
I think that is part of what we're struggling with here.
Defendant
right?
has benefited.
If they never asked him to do that. So if I say only introduce people to me that are going to be willing to pay 6.5 million, and he introduces someone who's going to pay 6 million, that's not what they asked for.
Well, you restitution lawyers might have an answer to that. It might relate also to that separate factor of whether it's unjust. And I don't know. These 4 stages might not be as watertight, hermetically sealed from one another as perhaps, in my ignorance, I might think. But I can see there's a sort of relationship across all 4 of them in a sense. So I don't really know.
If there are restitution lawyers out there who would like to give us a steer on that, do drop us an email. Unpacking.
Yeah, or do your own podcast.
We're back to what we started off with Maggie telling people to butt out. Do drop us an email, unpacking.contract.law@gmail.com, if you have any thoughts on this, or if you think we've got it wrong, and we may or may not pick that up. If you do, and also if you've got any cases you want us to discuss, that would be really interesting. I thought I'd drop our email in there again. We have some suggestions, and I think we have a suggestion for the next podcast as well. But anyway, yes, that was a we don't really know much about restitution. So where do I sit on this one? That was the question, wasn't it? I don't find the implied term, although I don't think the decision is correct, I do not find the implied term basis to be successful.
How's this working then? You don't agree with the majority, and yet
that
you
just
don't
means
agree
I
with
should
the
be.
minority.
And you know what? That just means I should be on the Supreme Court. Clearly.
Yeah, Maggie, you agree with the majority. I disagree, so therefore.
And didn't I predict it? Didn't I predict it?
The third way.
So we're going to have to wait for the judgment to come out from Dr. Dodsworth as to what the Supreme Court should really have
Absolutely. Why not? What a note to end on.
Great.
So
Okay.
in the summary, we have as little clue as anybody else about restitution, and we do not agree in any kind of way at all. I think that's the perfect. With one another. Someone.
We agree with various.
I agree with myself.
Yes.
I was about to say, I'm not sure I can sign up to that either, Severine. I'm not sure I always agree with myself at all.
Is it HMS Pinafore? Something about never or hardly ever. There's a song.
Okay,
I think.
sorry.
People out there who are Gilbert and Sullivan devotees might know that one.
Take your word for it. On that note, thank you very much for joining us, and we'll see you in the next podcast. Thank you.
Thank you. See you next time. Bye-bye.
Thank you. Bye.